Linda Ritz, and we are going to call today's meeting on March 12, 2014 to order. May we have the roll call, please?
Present.
Present.
Present. Yes.
Present.
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 And I'm here too.
Let me introduce you to Tony Walker. The forgotten one, the lonely one, you know me.
All right, let's stand for the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, approval of the agenda. We have several requests for some changes to the agenda. First, we have want to add an action item to extend the testing window for IMAST. You received information regarding extending windows for the other tests, and IMAST, we just neglected to send a separate memo. So do I have 3 board members approving an action item? So I see that, so we will add that to the agenda. In addition, we have a request to add another action item. Sarah, would you like to speak to it?
I'll hold and read my comments in the
Sure.
actual item, but I would like to add an action item for us to discuss ways that we can help support schools as they work to implement the new standards that will be approved in late April.
Do we have at least 3 members who would like to see that on the action? All right. I'm just going to list it as standards implementation.
Sure, it's currently on discussion there, so that works.
At the prerogative of the chair, I'm going to reorganize a couple of items, if you don't mind. I'm going to take, before we have action on rulemaking for REPA 3, we're going to have the discussion on REPA 3. In addition, with the new addition of the action item for standards implementation, we are going to hear the standards implementation discussion prior to the action. And also, I'm going to move all the standards items on discussion to the beginning of the discussion agenda. Okay? So the discussion agenda will begin with standards review update and then followed by standards implementation. Any other requests for changes? Do I have a motion to approve the agenda? Second?
Second.
All those in favor say aye.
Aye.
Those opposed? Motion carries. Approval of the minutes. You have both the January 15th and the February 6th. Do I have a motion for approval?
So moved.
Do I have a second?
Second.
Any discussion on the minutes? All those in favor, please signify by saying aye.
Aye.
Those opposed? Motion carries to adopt the minutes of January 15th and February 6th. Statement of the chair. I simply want to reiterate with you regarding the ESEA waiver that we currently have with the federal government, and that we have, from my department, I personally have been in contact with the U.S. Department of Education requesting that they release the Monitoring B report so that we can go about working on any items they feel that we should still need to be working on. I'm getting worried that there may be items that we perhaps might need to work on, and school's going to be out of session. We have 60 days to implement some things perhaps that they might say we need to refine. So I gave you a little fact sheet regarding the status of that now. And so we still have not received the report. We were supposed to receive it the week of the last week of February, but it did not arrive. So we're still in contact with the U.S. Department. Any board member comments and reports? Seeing none, we have a very lengthy agenda. At this time, we have public comment on items to be addressed with the board. I'm going to allow some flexibility here. We have a very, very lengthy meeting, and I have 4 people who have requested to speak. Of those requesting to have public comment, if there's anyone here that wants to speak now because they may not be able to stay for the entire board meeting on a particular topic, I'll be glad to entertain that. So we have Jackie Roten or Tom Brugan and Carol Craig and Jill Shudd. Anyone wishing to do their public comment now, or would you rather wait until the topic comes up? Yes.
Good morning, Superintendent Ritz, and good morning to the board. I am Carol Craig. I am speaking as an educational consultant and as a community stakeholder, and my comments reflect my concern about the social studies standards. I appreciate this opportunity. I'm an educational consultant, as I mentioned. I'm a retired educator, retired principal. I was trained by the Department of Education for the Leadership, Coaching, and Mentoring Program, and I've also been trained through the Bethune Institute of Multicultural Education. The concern that I bring is one that has come up in the community regarding the need for more descriptors as it pertains to the history of all significant groups that participated in the history of our country. As we examine the current social studies standards, we were concerned that perhaps we have not included sufficient information on the history of African Americans. As I went through each of the standards and the descriptors, what I noted is that we have a significant history of Native Americans, and that's to be commended. I thought that was very important, and it was so great to see that in the standards. I started with the first grade and went on. However, we don't have mention of African Americans. And what happens by 4th grade, as I looked at the standards, in those descriptors, we have comments on the civil rights movement. We have comments on, it says migration to the north from the south. However, that does not deal with the significant contributions of African Americans even when they were enslaved in our country. So there's a whole list when you Google the history of African Americans and their significance to the country, that all of that information exists. So the question may be asked, why is that so significant? I'm sure the board members are quite aware of why that's significant, but I do want to bring out, if we stay data-driven, we know that the groups that are performing at the very bottom in our state and across the country are groups of color. So we have not only our Native Americans, we have African Americans, and we have Latinos. If we look at that data, and we also look at the data for the state of Indiana, 97% of our educators in Indiana are teachers who are of European American ethnicity. So with only 3%, we have a significant issue in terms of being able to relate and have the cultural background and knowledge for all of our students. We also look at what's happening with the population of students in the public schools and throughout our schools, the same as the nation. Even though Indiana has only a 9% African American population, we know that our schools are now getting to 40%, and we have schools that are significantly 67 and even 90% African American, whereas the teachers are European American. Also, when I was Human Resources Director, there was a study that showed that the majority of the teachers in our state, and this is very natural, want to teach back in their hometowns. Many of those hometowns lack diversity. So what happens is the teachers, because of job openings, end up in schools with higher diversity without the significant knowledge and training. Because we are so standards driven, teachers are going to refer to the standards. That's going to be the expectation of the principals. That's the expectation of the board and the superintendent. So if we're not explicit about what we want and what we need, then it will be a drastic overlook. When we look at what was given to us by the Disproportionality Commission that was instituted back in 2007 by the former governor, in that commission it outlined the 5 major areas that contribute to disproportionality in test scores, graduation rates, and other outcomes that we use for performance. And one of those criteria was cultural mismatch. So if we look at cultural mismatch and we take that back to what are we emphasizing in our standards, then I would ask the board and the State Department, and I want to give the State Department kudos for how cooperative they've been as we have asked these questions in the last few weeks of the department. We were asking, where are we with Black history in our social studies curriculum? So again, my final words are that we take a deeper look and look at the descriptors, realize that we have inadvertently omitted African American history in terms of contributions in those descriptors with the standards. And we want to be sure that we are focusing on 21st century as well. I did some Googling on standards across the nation in terms of social studies and found that there were some key words that we might note. There were some key words such as individual development, cultural identity, global connections and exchange, and these words such as interaction of cultures takes us way into the 21st century where we want our children to be in terms of interacting with all peoples of all diverse ethnicities. Thank you for your attention.
Carol, just a remark. I'm sure you probably have been working with our liaisons at the department regarding
Yes.
your concerns.
Yes.
And so I want to formally actually invite you to work as we work through the resources that are going to accompany the standards, because I think you'll find them quite extensive,
Great.
and really guide curriculum perhaps at the local level to give teachers a variety of cultural diversity information.
Great, great. Thank you so much
You
for
are
that.
welcome.
Thank you.
Is there anyone else on the list that wanted to speak at this time? Okay, seeing none. Moving on to the agenda. We have a consent agenda, excellence in performance grants. Do I hear a motion to approve? You may.
I just had some questions about the, in Indiana, we've got, I guess I looked at the list last night, and it's like about 1,000 Title I schools. And so the grant is going to the teachers in a D or an F school. Sorry. We have about 1,000 Title I schools in Indiana, and so there are 54 schools on the list. And the 54 schools that are receiving the grant money are the schools that have a D or an F. And I would like some clarification, or I wondered how we came up with that list of 54, and also just, you know, I look at like all of our Title I schools and how much work those teachers do and how much effort it takes, and I think about the school that got a C, who squeaked through with data, and what a shame that those teachers don't get the recognition and the bonus or the grant that, because they did a good job with the same socioeconomic or student body.
Your point is very well taken. This is a specific grant on the Excellence in Performance Awards that is solely for the retention and recruitment of teachers in focus and priority schools. That is the extent of the grant. We're not allowed really to expand upon that. And so we made it a non-competitive grant this first time around because we just got the information as to who the ratings of the teachers. And so we put that out as a non-competitive. So it is limited to that. I will add that there's a school performance awards grant of $30 million that will start to go out that does acknowledge all schools and all teachers who are effective and highly effective. And that's going to be coming out here real soon. But this particular grant can only be focused on that. In addition, we're going to be working, gathering some information from superintendents about means to use some of the next pot of money to actually attract teachers to work in focus and priority schools. So it's limited. So I totally
I just,
agree,
you know,
Carrie.
you
Totally
know, you look
agree.
at a school where they're
I
Title I and
totally
they've-
agree.
They've squeaked in that C, and like kudos
Totally
to
agree.
them, and
I might
so-
also add that the school performance grant, you know, is going to be, the state legislature that passed that, it's graduated. You know, it gives teachers who work in A schools more compensation than it does the teachers who work in the F schools. So there's, the dialogue, I
just-
understand.
Yeah, and I look at, you know, like some of the elementaries even feed into a middle school, and the middle school may have gotten a B, and they've got the same students in
I
essence.
understand.
And so, all
I
right, thank you.
understand
Sorry to
totally.
question.
Yes, Dan?
I don't think we have enough mics. Can you pick that up on your? Speak up. Use a coach's voice. 4,382 effective and highly effective teachers. What's the denominator? What's the total pool of teachers that were in these schools? Do we know?
Reese, are you in the, or Sarah?
Good morning. As you know, we just finished collecting the data for the 2012-13 DOE ER report, and that's our data collection report that we receive the final evaluation. So at the April board meeting, we will have all of those scores tabulated, and you'll be able to see in a statewide, in a corporation, and in a school,
I'm
the
just
ratings.
asking a very simple thing. Of these schools that are eligible.
Of these schools.
How many teachers were eligible, and we have 4,382 versus how many teachers total are in these schools?
We're still working with that data. They just submitted.
Well, you got this number, so I assume you have the whole number.
But they only submitted for effective and high. So these, I also want to
Okay.
clarify that they also apply.
So you'll have it next, let's
Yes.
make that real clear.
Yes.
I'd like to know that.
Yes,
you.
absolutely, yes.
Thank you, Sarah.
Thank you very much.
David?
Good morning.
Good morning.
The appropriation for fiscal year 2014 was for both public schools and charter schools. And I started to go through the extensive list of everyone that received it. And out of the 4,382 teachers that are receiving it, how many are charter school teachers, just approximately? Is it 1%, less than 1%, 20%?
That applied for, so I also want to make sure everyone understands
They
that.
had to apply for
They had to
this.
apply. So
Sure.
every priority and focus school, DNF, were eligible to apply for this grant. And so then we took all of those. It was open for about 3 weeks. We posted on our website, sent out Learning Connection, and in the DOE dialogue as well. And so all of those that applied that were not already getting and receiving either a federal grant or a state grant for teacher performance, they were awarded. They're on this list. They were considered eligible. So they applied. They were a DNF school, and they told us how many highly effective and effective teachers they had in 12-13. You will see them on this list.
So those that have applied,
Mhm.
those that received the money, do you have any idea how many of those are from charter schools or independent schools?
I could go through and figure that out, because those, it's in that column. I would say not very many. I think there are probably 4 or 5 that are charter schools.
I would just suggest we get the data, and then on my, I want to know the math on this. I want to know the math on who applied, and then how did it shake out, please?
Since you're getting data, I'd be curious to see the percentage of people that were eligible to receive it, what percentage actually applied.
Okay.
I think that's a number we really need. If it's a low percentage, we may need to take a more affirmative action to encourage people to apply. So until we have some data, it's hard to make data-driven decisions.
Any more comments? Back to the consent agenda. Do I have a motion to approve the consent agenda?
So moved.
Do I have a second? All those in favor say aye.
Aye.
Those opposed? Consent agenda approved. Now we are ready for an adjudication. Oral argument, Hamilton Heights School Corporation versus Fayette County School Corporation. Give me a moment to actually get my formal papers out here. I believe you all received information electronically, and then it looks like you received double copies of that very same information this morning. And yes.
Just for clarification, when we come in, sometimes there are packets of materials. I know you found a packet as well. Was the packet that we have provided by staff, and can they verify it's what we have electronically? Because I don't want to work from two
I already
sets.
spoke with Michelle
Okay.
McGowan, and it is to be the materials that we already possessed.
Okay, so it's just hard copy of what we've already
Yes.
been given. When I
Yes.
come in and I don't know where it came from, I have to ask. I just want to make sure I'm working from the same documents. Thanks.
Correct. So good morning, and welcome everybody. Today is March 12th, 2014, and the time of the adjudication is, it looks like it's 9:35. We are here today in the matter of Hamilton Heights School Corporation versus Fayette School Corporation, which has been assigned a State Board of Education cause number 1305009. This matter involves a dispute over transfer tuition between Hamilton Heights School Corporation and Fayette School Corporation, and presents an issue of first impression to the board. And so I guess I want to re-emphasize that this is the first time this type of an issue has come before the board. It's not been ruled on before, so it will set precedence. After argument concludes, the board has the following options, and I just want to be sure that you understand our options. A final determination at today's hearing can be made, which will be reflected in the minutes, so we actually can make a decision here at the board meeting, at the adjudication. Or the board can take this matter under advisement and come back at a later date to actually render a decision. Or the hearing officer's decision can be adopted, and you have a copy of the hearing officer's decision and have reviewed that. Or the board can remand this back to the hearing officer for further action. So we have 4 different possibilities, and at the end of the adjudication, I will ask for a motion on one of these, and we'll proceed. This matter is being recorded, so we do ask that all who speak today please use the podium and microphone when addressing the board. The parties are present today by counsel. Would counsel for the petitioner and respondent please introduce yourselves and any other counsel participating today, starting with the petitioner.
Good morning, members of the board, Superintendent Ritz. My name is Andrew Manna from Church Hiddle and Antrim, representing Hamilton Heights.
All right, and if I could have the respondent. If you could come to the podium, please, just because we're recording. Thank you.
I'm Robert Rund, counsel for the Fayette County School Corporation, and Dr. Hodges, on the merits of this matter, will also have a few brief comments as a part of our presentation.
That will be fine.
And it's our understanding that there was going to be a preliminary procedural matter that goes first.
Correct. We're going to get to that point in just a moment. Correct. The procedural history of this matter is as follows. Number 1, on May 15, 2013, the petitioner filed a request with the State Board of Education requesting a transfer tuition hearing in order to seek payment of all costs and fees associated with the education and transportation of the student, SL, along with fees associated with the administrative proceedings. A hearing examiner was appointed pursuant to Indiana Code to handle all pre-hearing matters and to conduct the hearing on the merits. The hearing took place on September 6, 2013 at the Indiana Department of Education. The hearing examiner requested further briefing, which briefing concluded on November 11, 2013. The hearing examiner issued his proposed findings of facts and conclusion of law on November 26, 2013. On December 11, 2013, the petitioner submitted its objection to the hearing examiner's proposed findings of fact and conclusions of law. On December 31, 2013, the respondent submitted its response to petitioner's written objections. Before we begin with arguments, are there any board members who feel that he or she cannot sit as an impartial decision maker in today's meeting? Seeing none, the hearing will proceed as follows. Hamilton Heights, the petitioner, filed a motion to strike exhibits from Fayette. The respondent would like the board to consider today that were not introduced at the evidentiary hearing before the hearing officer. Fayette filed a response to said motion. Today's hearing will begin with the parties presenting argument regarding the motion to strike and response. Both parties will have 5 minutes for argument. Further, the petitioner may reserve time for rebuttal since the petitioner has the burden. Rebuttal arguments should be limited only to refute arguments made by the respondent. There will be no surrebuttal. After the board determines whether the exhibits at issue may be considered, then oral argument regarding transfer tuition will occur. In both phases of today's hearing, the board members may ask questions of counsel to clarify points or to aid in their understanding. If a question is posed by a board member and the time limit expires while counsel is answering, counsel will be given a reasonable amount of time to conclude his or her answer. Are there any questions before we begin? We'll begin with the petitioner's motion to strike and the respondent's response. Attorney Andrew Manna for the petitioner may begin. You have 5 minutes.
Good morning again, members of the board, Superintendent Ritz. My name is Andrew Manna. Along with me, Jessica Heiser is an associate in our office, Dr. Derek Airwood, the superintendent, Kristen McCarty, the treasurer, and Dr. Steve Warnhoff as well. Peggy Jackson, the associate superintendent, is out of town and gives her regrets. Hamilton Heights is appealing a decision today dealing with an administrative law judge appointed by the Department of Education. And before we get to that matter, we need to address some additional information that was presented by Fayette County through their counsel, Mr. Runn. In this specific matter, as Superintendent Ritz explained, we had a August 1st, 2013 pre-hearing conference. In that conference, the parties discussed presenting information at the September hearing. We were going to bring information, bring documents, present witnesses, and the administrative law judge, as is traditionally done, as the gatekeeper of information for the state board. That administrative law judge would then look at the evidence and make a determination. Along the way, as past practice is with the state board, there are hundreds of other transfer tuition hearings like this, although it is true this is an issue of first impression. Previous transfer tuition cases, the state board doesn't hear evidence. You don't hear testimony. You don't have new evidence before you. It's not set up for that. You have the administrative law judge who does that. Otherwise, you would be standing up here and you would be fielding questions about hearsay evidence and relevancy. So the September 6th hearing proceeded. Both parties had their strategy. Hamilton Heights went first, presented their evidence. Fayette County, through their counsel, was able to cross-examine a witness. And this proceeded, and as Superintendent Ritz pointed out, in December of 2013, the administrative law judge made his determination. Now, Hamilton Heights is appealing that today before you. Mr. Elsner, a few minutes ago, you were talking about with the performance grants. It's a math computation question. You're going to see here in a few minutes the exact scenario with this hearing as well. Unfortunately, in January of 2014, Fayette went ahead and presented additional evidence, additional information, and I apologize, Mr. Oliver, for the duplication, but yes, the blue packets are Hamilton Heights information, and at the front of that is our motion to strike. So what we're asking is that you look at the fact that way beyond the hearing, way after the September hearing, Fayette, in our mind, unreasonably tried to submit additional information that was not before the administrative law judge. It seems that I could probably stop right there and ask you to make a determination, but I'll also address their legal arguments. Their legal arguments are as follows. They say that as the state board ultimate authority, that you should have discretion to hear additional information. Well, again, that's not been the past practice of the board when there's been transferred hearings. You hear and look at the evidence that's already been before the administrative law judge. So to change that now would be changing your process over time. Instead, you review the evidence that's already submitted in the packets. Second, Fayette argues that they are objecting to hearsay testimony presented by the Associate Superintendent, Ms. Peggy Jackson. Ms. Jackson testified. Fayette had an opportunity to cross-examine her, and at the time, they didn't object at all to her testimony. They didn't say it was hearsay. They didn't complain that it shouldn't be allowed. They didn't voice any of that to the administrative law judge. And now they want to come back and rebut her live testimony with filing some additional information at the last hour in January. Third, Fayette also says that they don't need to object to Ms. Jackson's testimony. They can file additional evidence if they need to. We simply disagree. Hamilton Heights disagrees. We think that, again, the administrative law judge is the gatekeeper of information for the state board. And it's extremely prejudicial to present cleanup rebuttal evidence after the hearing is already over creates bad precedent, and we think that you should make your determination based on the record, and I'll reserve any additional time I have for rebuttal. Thank you.
Thank you very much. Any questions from the board? Attorney Robert Runn, the respondent, now has the floor. You have 5 minutes, and there'll be a 1-minute warning.
Thank you, Superintendent Ritz and members of the board. Given the short amount of time allotted, I will only touch on a few key points here. Heights is attempting to muddy the waters by obscuring the real issues with technicalities. Let's look at the facts at the heart of their motion to strike. Heights presented testimony from Mrs. Jackson, their associate superintendent, that included her recollection of a communication she had with Miss Debbie Heinlein, then Director of Finance at the Indiana Department of Education, concerning how transportation costs are to be calculated for transferred students in a residential facility. Mrs. Jackson's recollection of that conversation was wrong. Heights also presented testimony from Mrs. Jackson concerning her recollection of communications with a former, now retired State Board of Accounts staffer, Mr. Stan Metler, concerning how transportation costs are to be collected for transfer students in a residential facility. Heights argued that the conversation and Ms. Heinlein's supposed advice was an agency interpretation or guidance or directive. That is not the case. Agency advice or guidance cannot be based on informal oral communications between one party on an issue where no formal or deliberate process or notice has occurred. In their briefs, they cited Stinson versus the U.S., which was a Sentencing Commission guidelines case, in support of their proposition that agency guidance need not be formal and could be mere commentary. That case does not support Heights' position. In Stinson, the agency promulgated guidelines manual and issued formal policy statements and official commentary. The court ruled the court shall consider only the sentencing guidelines, policy statements, and official commentary of the Sentencing Commission. Other cases cited by Heights referred to interpretive agency letters or advisory notes. No such interpretive letters or advisory notes were introduced in this case. By analogy, IDOE or State Board of Education staff would have to prepare written commentary based on the applicable statutes and regs, and the State Board of Education would have to formally approve it before commentary became official agency guidance on policy. No such formality was observed in Mrs. Jackson's private, informal conversations with agency staffers. Heights also argued that the conversation and Stan Mittler's supposed advice was an agency interpretation. That is not the case for the same reasons noted above. Fayette had no knowledge that the truncated proceeding, the parties had a tentative agreement except they wanted guidance on the formula of calculation, would involve presentation of conversations of former staffers and did not have an opportunity to evaluate the hearsay testimony given concerning those conversations in time to call those individuals which she quoted as witnesses to testify. The letter from Peggy Jackson to Jane Kellogg-Tollett, which was Heights' Exhibit 12, did not provide adequate notice that Hamilton Heights would offer testimony that Debbie Heinlein or Stan Mittler agreed that transfer or corporations, the sending corporation, would be required to pay in accordance with Hamilton Heights' proposed formula, or that that was a new agency position. The only paragraph referencing Debbie Heinlein or Stan Mittler merely stated Form 515 does give a brief outline for calculation. However, in my discussion with staff from the DOE, Debbie Heinlein, State Board of Accounts, Stan Mittler, when we first determined how to charge for transportation, they were not clear on how the formula should be derived, and so we calculate the cost that we incur. That's a quote from a letter by Ms. Jackson. Fayette did not read this vague paragraph to mean that Ms. Heinlein or Ms. Medler, and certainly not the respective agencies, agreed with Mrs. Jackson that transferor corporations could be required to pay in accordance with the approach or formula that Hamilton Heights was suggesting. Fayette did not read the quote "we" to mean anyone other than Hamilton Heights officials. 1 minute, okay. Additionally, omitting Mrs. Heinlein's affidavit and the emails of Mr. Ryan and Mrs. Heinlein would not be prejudicial to Heights. In fact, it would be prejudicial to Fayette to exclude the important evidence. Ms. Heinlein's affidavit comes from personal knowledge. She is competent to address the issues. It is reliable, and it was made under oath. Fayette did not object to the prior conversations that Ms. Jackson incorrectly recalled because hearsay is admissible in administrative proceedings. Heights, in crafting their presentation, could have fully evaluated its own witnesses' testimony. It is only after the testimony has been discredited does Height raise an issue. Conclusion, the little weight the testimony was given was appropriate and should be given even less weight here, given the rebuttal evidence that has been presented. As the ultimate authority, this board may hear additional evidence. Given the broad-reaching implications of this decision, it would be in the best interest of the parties and the public to hear all appropriate evidence. Heights argues that the affidavit is self-serving. Okay, thank you.
Thank you. Do we have questions? Yes.
Question, Madam Chair.
Yeah.
Was Ms. Heinlein presented or offered a confession?
No, and nor did we know that there was going to be testimony concerning what Ms. Heinlein supposedly said.
So at the point that the testimony came into the record, was there any kind of offer to made any offer to submit an extension to the hearing?
No, there was not. Again, it was a truncated proceeding in which the parties had reached agreement on the number for the previous year, but wanted guidance from the hearing officer going forward.
Now that the parties have rested, it's time for the board to render a decision. Sorry. Oh, rebuttal, sorry. Sorry.
Thank you, Superintendent Ritz. Mr. Rund mentioned the technicalities. Mr. Rund was the previous counsel to Hamilton Heights before I became counsel. Mr. Rund knew who he needed to call for this case. So in August, when we met, he knew what witnesses he should bring. As far as Ms. Peggy Jackson's testimony being wrong, it's not wrong in the sense of Ms. Heinlein is actually now a defendant in one of these matters. She works for one of the schools that Hamilton Heights is suing for transfer tuition. So she is biased now, working for a defendant party. So there's no way to sort through that now. That should have been done at the hearing. That's why we're asking you to stick with the original record and proceed on that today. Thank you.
Now that the
Chair, I move to grant the motion struck.
Second.
do we have any more discussion?
Yeah, I'd like to understand, you mentioned past practice. Is past practice set forth in law, regulation? Where is the past practice established?
The past practice would be from the fact that although this specific issue itself is unique, there have been previous transfer tuition hearings before the state board. If you go back and look on the state board website for those previous adjudications, you haven't heard evidence and testimony before. You take the administrative law judge record.
Yeah, could we hear from the board counsel on that point?
Go ahead, Michelle.
Sure. So part of this is established under 2026, the transfer tuition statute. And then in addition to that, the board adopted procedures quite a while ago while Dr. Reed was the superintendent and Kevin McDowell was the general counsel. So we have continued to follow those procedures. Both the hearing officer who served in this matter and I have continued to follow those previously established procedures.
May I ask another question while we have
Yes.
counsel up here? It would be appropriate, I believe, to send this back for further consideration by the administrative. If there seems to be some,
Well-
I know there's a motion on the floor, but I want to get some. We could send this back for further review, could we not?
Yeah, that would be one of the options. But
Correct, that I mentioned at the beginning.
Right, and I understand. I just wanted to make that really clear. So we have a motion on the floor, but we just want the board members know, I'm thinking it might be better to send back if what I read and what I've heard for further review of determining costs, et cetera, seems to be
Well-
some confusion, so.
And I
Correct.
think that's probably getting to the second matter,
Yeah,
whereas this is
correct.
just about the
This is
evidence, and that's
the-
getting to the matter of
We're
the
just dealing
oral
with the
argument
motion to
itself.
strike.
Thank you.
So we have a motion to grant the motion to strike, and we have a second. Any more discussion? All of those in favor of granting the motion to strike signify by saying aye.
Aye.
Those opposed? Motion carries.
Madam Chair, I have a
Yes.
follow-up motion as well. That is to move to bar any evidentiary testimony here in the proceedings today.
We have a motion and a second. Do we have any discussion? All those, go ahead, Andrea.
Can you explain that for me?
Essentially, all of the evidence that's part of this record now was included before the hearing officer. There's been a request or attempt to have someone other than the attorney speak to us, which would constitute further evidence, basically, at the, what really is an appeal level, the way these precedentially handled. So what would be appropriate, under my thinking, to what we've always done, apparently, is to only hear argument from the attorney at this point of the proceeding. Any evidence or witnesses or anyone that had anything to say substantively should have been done before the hearing officer.
So in other words, the folks who came from the school systems who want to speak during the next phase will not be allowed to?
Correct, it would be a re-litigation of what they've already had opportunity.
David?
I have a question for legal counsel. Does that action, if we were to adopt it, violate any due process requirements?
Yes, go ahead, Michelle.
So have we switched from talking about the motion to strike to Mr. Rund wanting to?
Yes.
To.
Correct. We moved on.
So we're into
So we
Tony.
ha-
Tony
we-
has a motion.
There's a new motion.
I
Okay.
just want to be
I'm
sure
just
that
tracking.
with
Tony-
us taking this motion, that we don't violate any due process provisions
Tony,
either
why don't
by
you restate
precedent
your
or by
motion?
law.
This motion,
Okay, I just wanted to make sure, because we kind of switched topics. So I did hear, and so,
on the other one.
okay.
And then I
And,
made a new motion to exclude any evidentiary witnesses.
okay. I will say that my understanding is that Mr. Rund was going to split the time, but that the representative from the school was not going to offer any additional evidence, but just wanted the opportunity to speak. But that would be a question for Mr. Rund.
So what,
My question's still on the table,
eh.
which is, if we were to take this action, does it violate any due process?
No, it would not, either way.
Thank you.
it would make it more efficient
Yeah, I mean, hearing
and
from
keep
any fact
evidence
witness
in the
at
proper
this point
place, yeah.
is arguably prejudicial to the other side. It should be limited to this.
So we have a motion, we have a second. We've had discussion. All those in favor say aye.
Aye.
Those opposed? Motion carries. We will now move on to the transfer tuition issue. The petitioner will be given the opportunity to offer argument in support of its objections submitted to the board. After the petitioner has made argument, the respondent will be given the opportunity to offer argument in support of its position. If the petitioner has reserved any time for rebuttal, the petitioner will be given the opportunity to make rebuttal arguments to the board. There will be no surrebuttal. Both sides will be given a total of 5 minutes to make argument. Rebuttal argument should be limited to only refute any arguments made by the respondent. Board staff will monitor the time. Attorney Andrew Manna for the petitioner may begin. You have 5 minutes.
Members of the board, Superintendent Ritz, thank you again for your attention to this matter. I am going to be talking fast and in the interest of time to get straight to the heart of the matter. Again, I apologize for any duplication, but I am going to be referencing tabs 1 through 6 in the blue binder. The heart of this matter, as we alluded to a few minutes ago, is a calculation issue, is a denominator issue. There are several analogous statutes. If you go to page 1 in your blue materials, the very controlling statute on this situation that both parties stipulate and agree upon is 2026-11-8B. A mother in Fayette County School Corporation needed to place her child at a facility located at my client's school district, Hamilton Heights. That mother is allowed to do that. There's previous state board decisions that say under the statute the mother is free to do that. It's not a special education placement. It's a specific placement under this statute. Now, having said that, there are some analogous statutes, including, Mr. Walker, 2035-8, that help us formulate and understand what is supposed to be calculated in this certain situation. So, under your tab 2, if you'll go to tab 2 for a second, in my blue materials, we went ahead and tabbed for you to flip to. Tab 2 is a letter from Fayette County Director of Finance that says they agree they need to pay tuition costs to my client, Hamilton Heights. So we know they agreed to pay the tuition costs. The calculation issue is focused on how to calculate transportation. Under that middle paragraph, you'll see a sentence that says, the total transportation cost should be divided by the entire population of Hamilton Heights. That is simply incorrect, and I'm going to demonstrate that for you here in just a second. So the transportation calculation is the issue. Under tab 3, it's the very last document in your blue binder, tab 3 is an agreed upon March 25th, 2013, signed from the Fayette County Superintendent, agreeing to pay transportation costs. They know that transportation costs are at issue here, and they know that they owe it. But where we got off track with the administrative law judge, with the hearing officer, is the calculation, and what is the right denominator. So let's go to tab 4. Again, I apologize for talking fast, but to utilize my time, under tab 4, you're going to hear about a Form 515. A Form 515 is the State Board of Accounts approved form for how you do this calculation. It does the math for you. At the top of that document is how to calculate the tuition cost. So you look at the class of school. This is a facility located at Hamilton Heights. It's a specific program for the students placed under the statute. You calculate based on the number of students at the top. You see there's 16 students under that formula 515. Now the real dispute again is down below and to the next page, transportation. How do you calculate transportation? Well, the analogous statutes, the guidance from the State Board of Accounts, the instruction manual, which I'll get to just here in a second, says that you're to isolate the cost. If you look at page 48 and 49 under your tab 4, you go to the top of page 49, it says look at the pupils that are enrolled in that program. It's the same calculation you did for tuition. It's right there for everyone to see. And if you use the instruction manual for 515, go to your tab 5. Under tab 5, pages 79, 80, and 81, it says use the class of school, isolate the cost, give Hamilton Heights the actual cost. On page 81 at the top, even though Fayette County says there's nothing in the transportation manual that instructs on this, there in fact is. At the top of page 81 under transportation section, it says use the pupils in that program. So the pupils that are at that Hamilton Heights program receiving transportation, and then under the heading where it says page 2, it says use the class of school. So you were to isolate the cost and give the cost exactly as that formula in the instruction manual shows. If you'll flip finally to page 6, under page 6, this is Heights' proposed formula on page 28, 29. They say they are owed $4,236 based on this isolated actual cost. Unfortunately, the hearing officer only gave them $1,000, so only a fraction of what they're owed. So we ask you to carefully take a look at this formula and adopt the proposal under tab 6 of Heights formula. I'll reserve any additional time for rebuttal or questions.
Thank you. Thank you, Mr. Manna. Attorney Robert Runn for the respondent now has the floor.
Superintendent Ritz, members of the board, what Hamilton Heights is asking is what they would like to be, the law to be, rather than what the law is. And the hearing examiner recognized this and indicated it would take legislative action. While it's clear that the child was allowed to be educated and transfer tuition be paid, the provision that provides for calculation, as the hearing officer correctly found, specifically in 3 places excludes the cost of transportation from that calculation. If you look at 2026-11-13, in the decision of the hearing officer, he correctly found that the statute excluded from capital cost, it excluded from operating cost, and from special equipment anything that had to do with transporting the student. So that's the starting point. It's not what maybe Heights would like the law to be, but that's what the law is. We're talking about, there's Exhibit 1 is an aerial photo that shows it's 1 to 3 blocks away by highway. Mrs. Jackson said it was 1 to 1.5 miles. And yet the transportation they're asking for was over $4,000. the way the Form 515 has always been used, and the hearing officer found this in his findings, was that you take the total number of students transferred by the transfer corporation, you divide it by the total number of students transferred, and that's how you come up with the number. And that explains the difference in the two numbers. The formula that he found was correct, was the formula that State Board of Accounts uses, and was also the one that Fayette proposed, as you can see on the next to the last page of his decision. He found in finding number 5, Indiana Code sections 2026-11-13C and 2026-11-22B exclude cost of transportation from the calculation to determine a transferee's operating cost. Likewise, Indiana Code 26-113A2 excludes equipment used to transport a child from the definition of special equipment. In terms of the instruction manual is in 2 sections. The section that's entitled Transportation section has no reference to class of school. The class of school reference calculation only has to do with transfer tuition, not the transportation. Secondly, this child was not in a special school. This child was transported from the Arcadia Development Center close by, as you can see from the aerial photo, to Hamilton Heights High School. She was in a special ed program, but she was transported to the high school that was just a few blocks away. The transportation section of the instruction manual says if a transportation contract has been entered into by the transferring and receiving corporations, calculate the transportation cost per pupil transported by dividing transportation costs by the number of students furnished transportation. That's how it's done. If Heights doesn't like that, or if the board feels that that somehow should be different, it needs legislative action, or at very least formal administrative rule that's promulgated, has a discussion and comment period, because this affects not only our 2 school districts, but many schools throughout the state. Informal conversations regarding agency guidance should not be allowed to dictate what the formal administrative position of this board is going to be that will apply to schools in both situations, both transferor and transferee corporations all over the state of Indiana. The evidence shows that a number of districts don't charge anything in these circumstances, and that's in the record. There's emails from 2 or 3 school districts with similar situations that do not charge at all. Do I have any time? Your hearing officer was correct on the facts and the law, and you should affirm your hearing examiner and not add further administrative and legal costs to either party by doing anything other than approving your hearing officer's decision. Thank you.
Thank you very much. Rebuttal, Mr. Manna has how much time? How much time does he have? 20 seconds.
Members of the board, Superintendent Ritz, if you'll turn to tab 5, Mr. Rund was just saying that the instruction manual does not use the term class of school. It does. Look on page 81 under the transportation section, and under the paragraph that says page 2, it says use the class of school. That is the isolated cost for this program. The administrative law judge got his math incorrect. I don't fault him. He just got his math incorrect. The reason for the $4,000, these are ambulatory students. Thank you.
So now, thank you very much.
Madam Chair, I have a question.
Yes, you do. Okay, go ahead.
I'll direct this to both parties. Do the parties agree that the transfers in each occasion here were because of disability?
There's no other. Yes, the students had to be transferred because most of them, and this specific student that we're talking about, has special needs and needs transported with special services in a bus.
I don't quite agree. This child was educated in Hamilton Heights. was transported by Hamilton Heights, and there was no problem with either of these. The mother decided to place the child in the facility, and she doesn't require a wheelchair. Yes.
So, I mean, if there's a disability in an IEP, I'm not understanding why 23, 35, 8, 1, and 2 aren't directly on point. 35, 8, 1 says that when there's a transfer because of disability, the settlement corporation shall pay for transportation costs that are necessary. 35, 8, 2 says that the transportation costs shall be paid when it's required by an IEP.
And Mr. Walker, I think 2035 guides us and is an analogous statute. Both parties understand that 2026-11-8 is a statute that is unique. This was not a case conference decision by Fayette County to send the student to the facility in Heights. We acknowledge that. Both parties do. So 2026-11-8 is a unique statute allowing parents to do this. But that statute you referenced does guide us in how transportation should be paid.
And why is it just guidance when it's speaking directly to the point of
I would agree. I'm guessing Mr. Run does.
It doesn't apply. It is not a situation where anyone made a decision that she could be better educated in Heights than in Fayette County. There was never a proceeding, there was never an IEP that said she needed to be educated in this facility. That statute doesn't apply. You can argue that that calculation may or may not be a model for how it should be used. If that is a model, the legislature, or by formal rule or regulation, this board needs to do that. But in this case, that's not the current law.
But there was an IEP that required her to be transferred.
Yes, and she was transferred before as well.
Well, so if that's the case and the statute says cost shall be paid, why should we do anything other than to interpret that as it says literally that actual cost shall be paid?
Because it doesn't apply. The statute applies is 281113, which specifically in 3 places excludes transportation.
This one specifically requires that the statute does not.
And just to clarify, both parties have stipulated transportation is owed. So
That's what I was going to say, that there's not a dispute that transportation is owed. The dispute is over the calculation of it.
Well, the difference is the statute here that really should apply says cost. It's not, it's explicit. It says cost. It's not formulaic. Really, when you interpret a statute like this, you go when you can based on the literal meaning of cost. In this case, I would argue that's actual cost.
If it applied, I would agree, but it doesn't apply. That statute is a whole different situation. There's been a decision that the child is to be educated in a different district.
I believe the statute applies.
So can I understand, you're saying the statute does not apply. Why is that?
Because that statute is geared for transfer where there has been either an IEP or an appeal where they've said the district of legal settlement is unable to provide a free and appropriate education or be better educated in District B. That's what that statute applies.
basically, 2026-11-8 is a trump card that allows families to move when they need to per doctor order over the case conference process. But still, from Hamilton Heights' position, the actual cost should be paid.
Brad?
I just want to make sure I have clarity, because my understanding is that you have a student who has a recognized disability with an IEP, transportation's built in as a related service. Parent voluntarily decides to move the child to the other district. Was the case conference committee ever reconvened to reaffirm what least restrictive environment was, or what FAPE was for the student?
No, I mean, there was no decision about this place.
So the IEP that was in place was the IEP set by the school district that the child previously attended?
No, when the student then came to Hamilton Heights, we reconvened at Hamilton Heights.
That's what I'm
To
asking.
include
Brandon.
transportation.
And we were, and Fayette was not a part of that.
Sarah?
Do we have anywhere in these documents, do we have a copy of the current IEP wording in terms of placement?
It's not in there.
No, yeah, this child's
Didn't know if there was
disability
any
was not a
reference.
question. It was the question over how to calculate
Right,
the
I was more
transportation.
curious from the standpoint of how the decision was made first.
Sure. Yes, David?
I have a question about the purpose of this hearing, and it's probably directed at Michelle. I tend to believe we're getting into the specifics and retrying the case. And we're getting into so many specifics, and I thought administrative judges already heard the evidence, made a decision. And if this is an appeal process, my understanding is we should be looking at violations of the due process, not retrying the particular case. And so Michelle, can you as a board counsel clarify, is this an appeal
Yes,
of a
this is-
decision of administrative judge? And if so, isn't it inappropriate to be getting into all these details
Go
about
ahead,
the
Michelle.
specifics? Because we're really not retrying the case, are we?
So, under the transfer tuition statute 2026-11, it does set up the process where you have an independent hearing officer who then provides a recommended decision to the board. Sometimes that just happens sort of as a matter of process. It comes to the board and the board votes whether or not to adopt. In this situation, what we had was once the independent hearing officer created and provided the recommended decision, one of the parties appealed. So it is an appeal. And Superintendent Ritz has gone through what the options are in this as to what the board could decide to do today in terms of action.
So because it's an appeal, it seems to me it would be somewhat inappropriate to get into the arguments of the case and the details, because we'd spend several hours doing that. Do we intend today to spend several hours on this issue and look at the evidence? And the information provided today was here when we arrived. I haven't had a chance to look at all the evidence. Is that what we're doing today?
Well, the evidence that we received is the same that was sent to us quite some time ago, and probably more than one occasion, because this adjudication really was originally
Right.
scheduled in January and then February, and remember, we have cancellation of meetings. Correct. And so what you got today is really duplicate of what we've already seen and we've already looked at.
I
Okay, so
do want
then
to.
I go back to my question. In an appeals hearing, an administrative judge has already made a decision. Are we reevaluating what that judge did and then maybe usurping or trumping that judge's decision?
So I'm hearing, I think, two questions. First, I do agree that this is not an opportunity to receive evidence, and that's in the procedure, so we are not to consider any new evidence. Second, there are multiple options. So it is about the appeal of that hearing officer's decision. You can grant the appeal and either rule here today as to what you think the calculation should be, because that's what this is really about, or you can adopt the hearing officer's decision as it originally was. You can remand this back to the hearing officer for additional findings, because the hearing officer is the appropriate entity to make evidence to determine whether there is a need for additional evidence. And of course, the board could choose to continue to deliberate and not make a decision today.
But if we grant the appeal, we're saying the administrative judge made a mistake on some basis, and if we do that, we'd have to look at all the evidence and hear testimony and so forth, at least as one member of this board.
And I guess in actuality, that is true, because you have all the evidence before you.
Can I ask, did the ALJ consider or make a determination as to whether the law that Tony's talking about applies?
I don't think, I can't speak to what the hearing officer, but I believe, I think that we are
first ask
limited
Michelle,
to
then the
what is
parties.
in the opinion. The opinion written by the hearing officer at this time does not address the statute in question. And so if you wanted the hearing officer to make express findings about whether that applies or does not apply, then you could remand. But no, his recommended decision as written does not specifically address 2035.
Does he cite it at all in his decision?
No, he does not.
Let me just say, I think this is very important, not necessarily because of this case, where I think it really be $1,080 in fees, but for precedential value and how this is going to be decided going forward, we probably really need
So I want to clarify. So we will then have two opinions
No, there'll be
from
one.
two hearing officers, or?
No, the hearing officer's opinion is dead at this point. At the point that we've assumed jurisdiction over the appeal, we will issue an opinion that resolves the issue. So my motion is to take it under advisement and have our board council put together a draft opinion addressing this issue
So now,
for consideration at a later
so
meeting.
now I do have a question regarding process, Michelle. My question is, if we take this matter under advisement as a board, and we just, we come back later for a decision, we have to have an appropriate venue in which to actually hear the arguments again.
No, you don't hear the arguments. This is just for the purpose of drafting and agreeing on an opinion. You don't hear any more testimony.
About the application of the statutes in this case.
About the resolution in
No,
general
the whole
and
case.
what law
The whole
applies.
thing.
And I guess I'm questioning that you might remand it back to the hearing officer to actually look at other sightings in law that it might apply to. Go ahead, Michelle.
Can I just add real quick in response to Tony's, did you make a motion or was it
Yeah,
just
I
a
did.
comment? I mean, it seems to me that I would have a little bit of a concern about, not necessarily taking it under advisement, but drafting opinion when we haven't really as a board offered a direction for that opinion. So, I would want to, if we're going to take it under advisement, I would say let's take it under advisement, but not necessarily, draft an opinion. I do agree that there should be an opinion ultimately written, but I just have a little concern about, taking it under advisement and we haven't made a specific direction as to whether we send it back, whether we, approve or disapprove, et cetera.
And I agree.
Lord, I'm not sure if that's something that is more appropriate or folks to discuss now, or if we just want to schedule it as an item at another meeting just for discussion among the board. I don't know, maybe that can be.
So we had a motion, I'm just gonna go back here. We had a motion of which I asked a question about the motion.
Yeah.
So we've had some other questions about the motion. And so the next question is to Michelle about procedure regarding the motion.
So I would have some concerns about the motion as it stands right now, really for the reasons that Gordon just stated. I don't think that would be consistent with the necessary process for me to just draft something, because I think the only thing that I would be able to do is draft something that was specific to direction. And I think that if we're wanting a new opinion, the appropriate thing to do would be to send it to the hearing officer. And as I just heard you saying, if the board wants to take it under advisement or have additional discussion to think about direction, then I mean, that could be a possibility.
Those two things can happen at once, correct?
Yeah, I wasn't clear in the motion. The motion really should have stopped at, I move to take it under advisement. After that was editorial.
Can I address one procedural aspect of what you're talking about? My concern is, I think what you have before you, you have enough information. I think both parties feel that. My concern is with the remand to the administrative law judge, I'm going to guess Mr. Run may say the same thing. Either party that loses again with the ALJ, we're going to be back before you. So I think you have information to make a decision.
I think it's horribly inefficient for you guys.
Well, let me ask the question, if the ALJ has not considered the specific statute, 2035-81, it seems to me that that should be something that they consider and specifically address. Or are you suggesting that we, go, Tony, are you suggesting that we go ahead and say it applies?
Yeah, and
Right.
both parties have a difference of opinion on that that's already been stated. Correct.
And still do not.
The hearing examiner,
I think it is an analogous statute that gives guidance.
But you don't think it directly,
I would agree that the direct statute is 2026-11-8. I think we both agree on that.
And
The
that's
other
what was
statute
heard.
is a corollary that gives you guidance.
Brad, you had another comment?
Just a point of order, do we have a second on the motion?
Well, no, we don't yet.
Because I would
We
like
wanted to
ask
get
about
questions
amending
answered
it.
because he had a couple pieces to his motion.
All
So, Tony, you're,
Taken under advisement.
It-
My way.
all right, and when you take it under advisement, pending further deliberations, I'm gonna ask,
You take it.
I wanna ask you, what does that mean to you?
That would mean that the only issues left to resolve in this matter are purely issues of law that don't require the hearing officer to open back up to any other testimony or any further review. That ultimately, the law that applies here needs to be decided by the Board of Education and not a single hearing officer asking on behalf of the Board of Education. And that we implement whatever process the board sees fit after this date to consider the legal issues that are applicable and whatever process beyond that to get a written opinion.
I have a question. So if we were to take it under advisement and then decide we wanted a recalculating of the formula, wouldn't that be the hearing officer's job to do that?
Not necessarily. I mean, the issue as it is in dispute of whether or not they're going to use actual costs or formulaic costs. I think we have good arguments on both sides for, which one to do. And all the necessary evidence is in the record, as they both just said, for anyone at this level to make that decision without further testimony.
Let me ask a particular, and Tony, or we might ask Michelle to answer this. The law that we agreed it's under, is that how the calculation was made or under the analogous law?
The calculation was made with a misstep from Height's position on what the denominator should have been. The ALJ used the wrong denominator.
So even on the, let me ask, or Michelle, because if we could determine what law applies. Well, so Tony, if I would like to do two things at once in the motion. Let me suggest this and see if it goes back to administrative law judge to have this sorted out under what law to make sure it's clear, and then what law you use, is the calculation correct? We could still have it under advisement and get some more information for the decision when it comes back.
I see two things happening with that. So let me
I-
go over
but I'm
our
suggesting
four
still-
options again.
But I just want to stick with Tony's suggestion one time. Can you do those two things at once with your motion, or you don't want them to go all two at once?
I mean, yeah, and you get into a unique situation, I guess, where you would remand it back with specific orders to the hearing officer to just consider the appropriateness of the additional statute, and then maybe make.
And if the
conclusions of law as
statute is
relates
agreed to,
that.
is the calculation correct, then it can come back here with the advisement in the meantime.
But my point is that that's a significant decision that will have lasting impact that probably shouldn't be made at that level.
Well, it isn't a final decision at that level, it still comes back
I
to.
know.
So I see two things happening here. So, through the discussion here just of the motion and questions about the motion, Tony, I hear that there's one of process. So if we take it under advisement pending further deliberations, to me, that means that we've got all we need, and we're just gonna come back later and we're gonna make a determination. Okay, we're gonna go back and study it, and we're gonna come back and make a determination. If we remand it back to the hearing officer with the caveat that they also look at this section of the law, then that's different to me, and that's a whole different motion.
There could be two caveats in there.
And that gives direction to the hearing officer, and it also gives us another piece of information that we may need for the appeal. Then our other option is that we just adopt the hearing officer's decision, of which we've read. And then the other one is we can make our own determination here today.
Superintendent Ritz, I think both parties just agreed. We don't necessarily, both parties really aren't interested in the remand, just so you know both of us.
Well, it was my understanding that you already had taken it to the hearing officer and had it under what you considered to be the appropriate law. And that's what the ruling in the hearing is. To me, the dispute before us today is simply the matter of how it's calculated. And you have a difference of opinion in the calculation piece.
And whether excluding transportation from section 13
Correct. So,
You know, if both parties are agreeing that the law doesn't apply, then I don't know that's are necessarily our case to send it back to the LJ to, you know, to make an opinion on, you know, whether the law applies or not, if both parties are before us saying it doesn't.
I said it's an analogous statute.
Andrea?
But you said it wasn't directly.
It's not, yes, 2026, 11A, I would agree.
Okay.
I'm not.
I'm going to let Andrea go ahead and speak, but then we're going to get back to some motions.
I'm not prepared to cast a vote today, so at minimum, I believe we need to take it under advisement. And I think a more thorough review, now that I've heard the arguments and understand it better, I think a more thorough review would put me in a position of being able to make a vote at the next meeting.
All right, so, Tony, you had advisement, and you wanted to end it with a period there, so that the board can take this matter under advisement pending further deliberations. So that's a motion on the floor. Do I have a second? Any more discussion? Brad?
I just want to make sure there's clarity that we would actually get in that advisement this question, a legal opinion on which rule applies, so we know how to determine whether or not the calculation was done correctly. That's part of what that advisement would be.
And we should probably consult Becky Bowman.
Exactly.
Especially, and some other people.
And address that whole concept.
I mean, it's a legal decision that,
I agree.
quite frankly, I'll respect word, it shouldn't be left to the litigants here.
And I
It's
agree.
something that's gonna have lasting effect as to how this is played out. So we need all of the top sort of legal people, you know, in our department, the board, special ed, to be involved in crafting this opinion.
Well, if that's the case, I don't think our hands, if assuming the board were to approve a motion to take it under advisement, I don't think our hands would be tied to necessarily make that decision to send it back at the next meeting, if that's what ultimately we decided was the best
So we
course
could
of
still
action.
send it back at the next meeting if we
Mhm.
wanted, or
Mhm.
after advisement.
If-
Michelle, are you on the page?
So,
Does
we
Michelle
have,
agree?
Michelle? Basically, the question is, taking the matter under advisement pending further deliberations, what does that actually mean?
So I think Tony did an excellent job of describing it earlier. It would be that you determined that you don't need any additional evidentiary determinations from the independent hearing officer, that you think that there are legal questions that need further consideration. I will say that I'd be happy to, since I am counsel to the board, I'd be happy to draft informations, act as a judicial clerk, and I'd be happy to collaborate with Becky Bowman and others to get the best information and analysis to you all for your consideration to make a determination at the next board
I
meeting.
second Tony's motion.
It's already been seconded,
Is it?
I believe. We were in discussion.
Okay, then I want to be third.
All-
I didn't have the math right
All
again.
those in favor of the motion signify by saying aye.
Aye.
Those opposed? Okay, the board will take the matter under advisement pending further deliberations. Thank you very much to both the parties today. So, Michelle, the last part of my comments here, do they apply? Says this will conclude our oral argument. Please be advised that pursuant IC 20-26-11-15, notice of the state board's determination will be mailed to each party via certified mail. So that will still occur?
That will occur after the next board meeting, after we've made a determination.
That's what I thought,
Yes,
that it
thank
would
you.
not apply here yet. Okay, thank you very much. We are now ready for new business. Let's see, how about, you want to take like a 5 or 10 minute break? Let's do that. 10-minute break, please. We'll be back here at 10 till 11.